Justices of the Appellate Division Court of Courtroom, hear ye, hear ye, hear ye. All persons having business before this court draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. The first case on the docket for oral argument is People versus Engels, case number 683, Engels. Good morning.
Good morning, Your Honors. May I please the court? Axel Lecomte for Mr. Engels. I'm going to focus my argument on points 1 and 2. First, on point 1, Mr. Engels should not have been convicted because he testified that his intent was to harm himself and not prevent Correction Officer Smith from performing his lawful duty. First, we have direct evidence of this. Mr. Engels testified at trial. He said, I didn't want to obstruct the officer. I wanted to harm myself. He testified that he could not control his emotion when he was.
So striking the officer with the monitor that he ripped off the wall, that's intent that he intended to commit suicide?
Mr. Engels was acquitted of this conduct. The indictment was really clearly divided between count 1 and 2. It was everything about the monitor, count 3 and 4 about the struggling. Because he was acquitted of counts 1 and 2, I believe that it was not proven beyond reasonable doubt that he struck the officer with the monitor. And so I think this court could not consider this conduct when they look at his intent to prevent the officer during the second part of the incident. Contrary to what the people argued, it's the only proof that he intended to harm himself. It's not only his own statement. The complainant testified that he witnessed, right before the incident, he witnessed Mr. Engels getting agitated, being insulted by the nurses. He told the doctor that he was worried Mr. Engels would harm himself. He also witnessed him trying to rip up the wires and eat a lot of stuff, and especially pulse monitors. And we know from the testimony that when Mr. Engels try to harm himself, he's often eats things.
There's no question that the evidence showed that your client was trying to harm himself. The question, it doesn't preclude the possibility he was trying to harm Officer Schmidt as well. And Justice Montour referred to one act where he pulled a long metal arm off the wall and hit the officer with it. That might be reflective of his intent to cause harm to Schmidt. I understand that the injuries were caused later, but he also, did he not, your client, make statements that he was going to harm Officer Schmidt and his entire family before he did so? I think the way the people look at it is that his statements are reflective of his intent and he carried it out.
So first, I understand that it's possible that he tried to harm himself, and it would be hypothetically possible that he also tried to harm Officer Schmidt at the same time. Here, we are not looking at trying to harm Officer Schmidt. It was just preventing him from performing his lawful duty. I think it's possible that he could have two intents at the same time. Here, I think we have direct evidence that he did not. I understand what the court may infer from his conduct, and I understand that in other cases, the ones that usually deal with officer like Metales and Franco and what the people cited, I understand that usually the people we can infer that they want the natural consequences of their act. But in all these cases, you didn't have the defendant that testified that that's not what he wanted. And so I think that's really, for me, that's what this case is about. The
officer, when he saw your client doing that and becoming a little bit agitated and ripping the monitor off, the officer came in and trying to perform his duties to restrain Mr. Engels.
I understand.
But Mr. Engels then proceeded to take those other actions with respect to harming the officer.
I think we have clear testimonies.
Isn't that part of his duty then as an officer trying to restrain Mr. Engels?
Yes, I agree that I do not contest that it was the duty of Officer Schmidt at that time. I just don't think that based on the testimonies that we have and the evidence that we have here, we can say that when Mr. Engels was just standing there. And again, I think what we can distinguish from like the other cases too is that there is no, when Officer Schmidt was injured in his hip. And again, I think that's important that Mr. Engels was acquitted of the first two counts. I understand that we are coming back to the incident with the monitor, but I think honestly, we really don't know if it happens. I understand that there is testimony, and in another case, we could consider that testimony to infer his conduct, but he was completely acquitted of this conduct. It's not like the trial judge decided to go for a lesser included or something like that. So
Well, did the trial judge really say that though? Trial judge he acquitted him of the aggravated assault on the police officer, but he convicted him on assault on a peace officer. He didn't lay out in his decision what specific acts he didn't make findings of fact, did he? It's not in the record that he said, I don't credit this part of the testimony.
It's correct that there is no decision that explain exactly why he acquitted, but when we look at how the indictment was written, it's very, very clear that only counts 1 and 2 were about the monitor and striking, and count 3 and 4 were about the struggling and the hip injury. So again, he could have acquitted of count 1, do the lesser included count 2, and then do the same, but he did not do that. So I think because he was acquitted of the first 2 counts, the only counts about the striking with the monitor, we know that he did not think that it was proven beyond reasonable doubt. And I don't think this court can consider that, because it will go against the verdict of the first judge.
Yeah, we understand that you want us to look at the evidence right after that initial fight and see if that's proves intent beyond a reasonable doubt. We'll take a look at that. Do you want to touch on your second issue before we turn it over to the prosecution?
Yes, that's correct. I just briefly to go back to one question. I know that you mentioned some threat to the family. I think it was your question. We know from People versus Schompers that when there is factors that affect the volitional competency of a defendant, notably that the threat just have less weight. Here we know he could not control his emotion. Plus, we know that none of the threats that he made were confirmed. He never tried, and there is testimony about that, he never tried to reach for a gun, even if he said, I'm going to try to go for a gun. And we know he didn't know Officer Schmidt and his family. So I think the weight of this threat compared to other cases should be is reduced and should not heavily go against Mr. Engels. And just very lastly, I think here that we really, if this court validates this conviction, I think it's really blurring the line with strict liability. On my second point, again, I know a lot of was said about the brain injury, and I'm not contesting that. But again, he was acquitted of that, and I think the testimony about the hip injury is not enough for serious injury. He did say, Officer Schmidt said that he feel pain, 7 out of 10. We know that pain alone is not enough for serious physical injury. It has to impair your life. And there is no direct evidence that he had any impairment that was caused by the hip injury. He didn't say he could not walk. He didn't say he was restricted in any of his movement. He did not receive treatment for a couple of years. He does not take medication or therapy and is no longer seeing a doctor for the hip. I understand that he's still seeing a doctor for other issues. Again, Mr. Ingles was acquitted of this. The testimony about his disability and the activities that he cannot do anymore, they are not linked to the hip injury. First, and I think that's really, again, what this case is about here and the point that I'm really trying to do. He said he's disabled and he cannot work anymore, but there is no testimony that he's disabled because of the hip. The only doctor at the trial that said Mr. Schmidt is disabled was a brain doctor. Mr. Ingles said he's disabled based on what his doctors and the state doctors said. When he listed the doctors that he currently, at the time of the trial, he was still saying there were no mention of a hip doctor. It was everything about his vision, his arm, and his neck.
Now this, am I correct that you're referring to count 3 only here?
That's
Count 3.
That's correct. Only count
And
3.
If you're right on this point that it wasn't serious physical injury, it was just mere physical injury, it would be, we would reduce it a notch to a Class D violent felony rather than a Class C violent felony, right?
Yes, that's
And he's
correct.
still a persistent violent felony offender, subject to a life sentence. He got the minimum here. Does that help your client at all? Both are violent felonies. He's a persistent. He got the minimum on that. But in any event, we understand. We'll take a very close look at the injuries on count 3 to see if it should be reduced or not. And we understand your point on your point 1 with the intent as well.
And I think it would help. It will reduce the sentence from 16 to life to 12 to life. It's not nothing.
Okay, thank you very much.
Thank you.
Yep.
Good morning, Your Honors. May it please the court. Mindy Van Linden for the people. If you'll excuse me for one moment, I do have several pieces of this where I apologize. I just want to start where LeComte Matthewson left off. Actually, the direct evidence we had of the injuries to the hip was by Dr. Freitas, who was an assistant clinical professor of orthopedics and family medicine and exercise and nutrition science, as well as being a primary care sports medicine physician. And he had diagnosed Officer Schmidt with a tear in his left labrum. That direct testimony talked about the injury, talked about what the labrum does, which was not something I was familiar with. It's like a stabilization of the hip, essentially, and the importance of that joint and socket itself. Just like in Falong, this officer went through lots of physical therapy. He went through aquatic therapy. He went through different shots to try to make it better.
He didn't take advantage of surgery, right?
He did not, but he was recommended for surgery due to this injury. He had never complained of hip pain before.
That wouldn't affect the status of this being a physical injury.
Nor a serious physical injury. That's correct, Your Honor. Because with regards to this, he needed surgery just in Falong. Just because he didn't get it doesn't mean he wasn't injured to that capacity. I would also suggest there was some discussion with regards to this that he said he couldn't go under general anesthesia. I know that the neurologist in this said, I didn't say that to him, but that doesn't mean he didn't go to other neurologists. He also said it's common that people don't just want to go under the knife. And he also said, Dr. Freitas said that even if he had that repair, it might not ever be the same anyway. There's also lasting damage regardless. Here. Dr. Freitas was the entire time he was providing treatment for Officer Schmidt. He had trouble ambulated and needing assistance walking, having to use a cane or a walker. He could no longer be a corrections officer due to both injuries, not just one or the other. He was opined specifically on page 140 that he was totally disabled from work as a corrections officer due to his hip injury, as well as his concurrent head injury. So it was due to both, not just one or the other. I would note too, in the People with the Phelan case, I believe that officer was still impaired 2 years after the injury, 4 years after the injury in this case.
Let me ask you this, on the intent issue, counsel suggests that because her client was acquitted of the counts with respect to the monitor, striking the officer with a monitor, that we can't consider that with respect to his intent on other counts. Do you agree or disagree?
I absolutely disagree, Your Honor. Initially, all of his intent is proven by the natural and probable consequences of all of his actions. I would also dispute the fact that he didn't have the capacity to control his emotions or behavior. Actually, Dr. Birch opined in the June 15th exam that he did have the ability to and capacity to control his emotions and behaviors. So specifically with regards to this incident, he knew exactly what he was doing. He was being told he was being moved back to the 9th floor where he didn't want to be. He was told he wasn't going to be able to watch the TV he wanted. He was on a special floor given special treatment, which is his purpose in this. Several of these different doctors, as well as the people who were caring for him in the jail, had opined on several different occasions that he had absolutely the capacity to control his emotions. His conduct was volitional when he wasn't getting his way. There was a couple of these I would like to just read into the record very, very briefly, Your Honor. I know you're very familiar with the record, so I'll try to be quick. One from June 15th was talking about the defendant's refusal to appear at several court dates. While it may represent poor decision-making, it doesn't represent a lack of capacity to proceed in this case and is not likely due to serious mental or intellectual disabilities. And again, in October 29th, competency exam by Dr. Liedenfrost, Dr. Liedenfrost opined, he admitted to the history of engaging in self-injurious behavior. The behavior appears to be frequently occurring in proximity to something that is not going his way, such as having the TV on that he wanted, moving to the floor he didn't want to be on, or something he's unhappy about. He explained, I really don't want to die, but I sense no other way to get help. He indicated that he was getting out, he would not want to die as he goes back to his family. Several of these occasions, he says he's going to kill himself, but he doesn't really want to die. And then he follows that up with, if he doesn't get his way, he's going to give it a license to kill. This is his quote, if they fuck with me, I'm going to try to kill them. I could get life for this case. So all in all, his intention was to get his way. And he knew and admitted during the case that he knew what the officer was wearing. He knew his duty was care, custody.
Would you intend to get your way by swallowing a piece of metal? Based on what he did?
Your Honor, I see what you mean. He absolutely tries to harm himself. Well, we don't dispute that whatsoever. However, you can get special treatment from breaking your leg, from harming yourself in certain manners, right? There was no evidence whatsoever he was trying to harm himself at this time. He had swallowed the plastic piece off that pulse oximeter about an hour before this incident when he was told he was going to be moved, when he was told about the TV. Right before he jumped up and got that monitor, he had been told he was going to be moved back down to the 12th floor.
Yeah,
so you can hurt yourself with
the wire monitors
he
in an attempt.
He said he was going to do that, but there was no evidence of that. I'm sorry to interrupt, Your Honor.
Yeah, the claim was that he bit those wires because he thought that would kill himself too. He'd be electrocuted.
So contrary to defense's contentions about there being no evidence to contradict it, there was no evidence to actually confirm those. Nobody saw him do that, and he was very closely watched through that very large window in 12, I think it was 02 as his room was. He was very closely watched. They saw exactly what he was doing when he was doing it. There's no evidence that there was wires that were frayed, that he tried to stick his mouth in the socket that would actually have electric. When you pull something off the wall, it's no longer electrified, right? So it just didn't make sense. And as Your Honors are well aware, leaving those credibility determinations to the lower court is what we normally do because they have the benefit of listening to Mr. Engel's testimony live. There's nothing that he said that was not unbiased. First, he's a very biased witness. Second of all, he actually said, well, I was just out of it, so I don't actually know what I'm saying in the first place. So how can we take anything he has into consideration. That's completely
I understand the
contradictory.
record, and you make those arguments very well in the brief, so we'll take a close look at that.
Thank you, Your Honors.
Thank you very much. Case number 685 is People versus Warren. Jason Warren. Mr. Gilman, good morning.
Good morning. May it please the court, Braden Gilman for Jason Warren. I'll focus my argument today on point one. Given the totality of the disclosure errors here and the prejudice to Mr. Warren's defense, 24580 dismissal was warranted. Notably here, there were disclosure errors when adequate contact information for two people's witnesses were not provided to the defendant until less than 2 weeks before trial, 28 months after indictment. Prior to March 16th of 2020, at no point were these witnesses in any filings by the people. They were not called at the grand jury. To that point, the defense did not know that either witness would be part of the people's case.
So you're not arguing speedy trial so much anymore. You're arguing preclusion was not an appropriate remedy. It should have been dismissal.
Yes.
And these are the two witnesses who were the passengers in the motor vehicle your client was allegedly driving that night, his friends.
That's correct.
Who we went to the concert with. I believe he was longtime friends with them, went to one of their weddings, if not both. The way that the people look at it is that your client was much more readily able to ascertain their whereabouts than they were. And does that factor in at all here?
It does not factor in. There's no carve out within CPL 245 for that these witnesses are known to the defendant. I think you'll see a lot of cases where specifically, for example, for complainants where the complainant might be known to the defendant, that they might have the contact information, adequate contact information for those witnesses. And assuming there's no protective order, they could reach out to those. It's still, I think it serves two purposes, particularly that there's a notice provision, and that's why defense here argued that preclusion was not enough, that this entire time that was given up, less than 2 weeks before trial, he was provided the adequate contact information, was able to reach out to these witnesses. He wasn't able to investigate during that entire time.
I think that the prejudice here, because now we're talking about prejudice because it's not speedy trial. If it's speedy trial, prejudice is irrelevant. Under 24580, prejudice determines what the sanction should be. The prejudice here, you say, is what the court precluded them from testifying, so there's no prejudice there. The prejudice is what your client wanted to call them, and he wasn't able to get in touch with them. Is that how he was prejudiced?
He was prejudiced by the inability to prepare for the people's case, which would have been that. And that's described in the November 12th, 2021 defense motion. He specifically does not move for preclusion because he says that is not, that cannot cure what had gone on during that time. And he only, I believe on November 10th, November 5th of 2021, he was able to contact these witnesses.
I mean, well, these were his friends. With their concert, they're long-term friends. Like he just can't call him on a cell phone.
It's not only the adequate he didn't have he wasn't communicating with the cell phone. He was communicating through Facebook Messenger. There was, I believe there was a number that was provided that was a digit or so off of what the two witnesses contact information was. And then in addition to that, it's not just the adequate contact information, but also the convictions of judgment. I don't think it's reasonable to assume that Mr. Warren would know the legal history, full legal history of these people.
Okay,
Um,
we'll take a look at that.
okay. Unless there are any other questions, we'll rest. Thank you.
Thank you.
Morning, Your Honors. Caitlin Porter on behalf of the people. As I read the brief, it did focus more on a speedy trial contention. So as far as that goes, we do have the 2019 statement of readiness from the people that would remain valid even into the prosecution into 2020. As for the argument on prejudice, I would entirely agree with Justice Lindley here that these were the defendant's friends. He had full access to them. And it's even included as part of the record. It was one of the attachments on defense counsel's brief. Motion dated 11/13/21. He did include email attachments from the defense counsel's investigator that the client, presumably meaning the defendant, was able to provide updated contact information, an updated phone number for one of these individuals as early as March. So they were in contact. The defendant even testified at trial that he had spoken with them about 4 times over video chat while this prosecution was ongoing and had told them that he was proceeding to trial. So they had full access to these witnesses. It was
Is there
actually
any indication they might have had some exculpatory testimony to give?
every inference would say no, that it was inculpatory because it was the defense counsel that was able to first obtain a written statement from these individuals. Defense counsel refused to provide that statement to the prosecutor upon the prosecutor asking. The defense counsel initially said that he wanted to call these witnesses. The court allowed him to do so. And then he obtained that statement and said that he would not be calling those witnesses and refused to provide the statement. So presumably there was something inculpatory, as well as the people's proffer that these individuals were with him the whole night, would have seen him drinking, were with him at the concert, were with him afterwards. So every inference is that they would have provided information that was.
The only exculpatory, I mean, he had a .10 at 4:30 in the morning and the accident occurred hours earlier. So if you extrapolate, it would have been a lot higher at the time of the accident unless he was drinking massive amounts of alcohol between the time that the car was disabled and the time the police showed up.
Correct.
And at given that hour, I mean, it doesn't seem likely. But anyway, we understand the point and we will take a close look at the arguments here.
Thank you. If there are any further questions, we'll rest on papers. Thank you.
Thank you. 686 is People versus Hills.
Good morning, Your Honors.
Good morning.
Good morning. Appearing for Appellant Tashania Hills. I'm sure Your Honors have been through the record in this case. It was a terrible, tragic case, and it took me a long time personally to get a handle on everything. But what I'm asking for today is very simple, and I don't think that this should be hard for the court to realize as well, that the weight of the evidence in this case favors finding that the defense did prove by a preponderance of the evidence Ms. Hill's defense of not guilty by reason of mental disease or defect. And I need to focus mostly on the testimony of the prosecution's expert, Dr. Barty. I've argued in my brief that there was a serious flaw in his testimony due to the fact that he really did not review the interviews with the police until very late in the game after he had prepared his report, and seemed quite stubborn about taking them into consideration with all of their very obvious evidence of her mental state during his direct testimony. I do think he was that was all adequately addressed on cross-examination. I think what happened in this case is that Dr. Barty went hunting for a motive when he could not determine a cause for psychosis. And he found a likely motive in the issues that Ms. Hills had had with her mother over her sexual assault in 2013 and the financial dispute that arose in 2015. And I frankly think that the jury might have been dazzled by this plausible motive. But the weight of the evidence in this case really comes from the testimony of Dr. McCord, Dr. Leswing, finding that she was having a psychotic episode, could not appreciate what she was doing, but also even, possibly more credibly from her father and her brother who were with her in the days prior to the attack and who realized something really wrong was going on with their sister, with their daughter. They had discussed getting her help. And Dr. Lesswing and Dr. McCord adequately accounted for the observations of other witnesses and their reports. And Dr. Barty rather stubbornly attributed everything to a devious plan to fake mental illness and brutally stab her mother to death.
Can I ask you this, counsel? Let's say that the jury didn't credit Barty, Dr. Barty. The burden of proof is on your client here. And is it possible that they may not have credited the testimony of your client's two experts who were psychologists, not psychiatrists? And it's possible that the people might have prevailed on this issue without even calling an expert, right? That's possible. They didn't have the burden. Your client had the burden. And if the jury didn't find persuasive the testimony, then really doesn't matter about what Dr. Barty says or doesn't say.
Your Honor, I think that a jury in a jury room acting as the Constitution intended can decide whatever they want. But the question isn't whether had Dr. Barty not even testified, whether my client still could have lost on this. What's facing the court now is the jury did hear that testimony and they heard conflicting testimony from Dr. Barty. And which one of those, which set of testimony was more persuasive to a reasonable fact finder? This court gets to sit as the 13th juror. It would not have been unreasonable for a jury to have found that the defense was proved by a preponderance of the evidence. And now this court must weigh the evidence that was before it. I understand what Justice Lindley you're asking about whether the jury could have found that Dr. Barty was more credible because he was a psychiatrist rather than a psychologist. But I would submit that that's not a valid, that's not necessarily a valid sole reason for discrediting the testimony of two psychologists.
Right, but we don't know that. But as far as like Dr. Barty discredit, he specifically addressed the defendant experts' reports. So it's a little more than you portray here. And Dr. Lesswing did not even interview the defendant. So the jury could have very reasonably looked at those factors and discredited defendants' experts, couldn't they?
Your Honor, I think that my position on Dr. Barty is that he disputed the diagnoses that were provided by Dr. McCord and Dr. Lesswing. And we know that Dr. McCord and Dr. Lesswing's diagnoses differed from each other. But the overall impression I've gotten from reading Dr. Barty's testimony and reading his report is that since they can't really come up with a good diagnosis for why psychosis happened, then there must not have been psychosis. And
well, Dr. Lesswing couldn't come up with an explanation either. Didn't he diagnose psychosis with unknown origin?
He did, but just because psychosis with unknown origin, I guess what I'm trying to say is that just because we don't know the cause of the psychosis doesn't mean that there was no psychosis.
Right.
And
can it be, and I don't know the answer to this, I'm not trying to box you in a corner, but can one have psychosis and not have a mental disease or defect within the meaning of the CPL? In other words, can somebody with a psychosis still understand right from wrong?
Your Honor, I think that the cases that I've cited have shown that yes, there can be a case where somebody has psychosis, but still understands right from wrong, that they wouldn't be not guilty by reason of mental disease or defect. But I think in this case, based on the testimony of the doctors that agreed she was having a psychotic episode, even though they didn't know the etiology of that psychotic episode or why it happened or why it stopped, that she did not have the capacity at that time that would make her criminally responsible. So I think that it's a little bit of a red herring to get caught up in the, well, we don't know why there was psychosis if there was psychosis, so therefore she must be malingering. I think that there's more under the sun than we can understand. And the record is very clear that she had been experiencing mental health problems for some time before they got very, very severe, before she broke with reality. There is plenty of corroborating evidence from that. She had been living a very successful, goal-oriented life for several years before this happened. She was attending her dream school at Howard University, and while there, she sunk into a depression. She sought counseling. She ended up coming back home, and things didn't get better for her. They got worse. They came to a head in February, and tragedy resulted. I think that if this court takes a serious look at all of the testimony from all of the experts, all of the interviews that were conducted with the police, I think that there is really no choice but to reverse on weight of the evidence. And I will rest on my briefs as far as my sentencing reduction argument goes, unless the court has any questions about that.
No, we understand that. It's a tragic case all around for the mother, your client's mother, who was brutally murdered. This is one of the most brutal murders we've seen in Fourth Department ever. And obviously sad from that angle. Your client was definitely had some struggles, whether they rise to the level of a mental disease or defect within the meaning of the statute, I don't know, but that's what we have to decide here.
Your Honor, if I may, one more thing, since you've brought up the brutality of the murder. Dr. Barty did refer to Miss Hills as somebody who would resort to violence to solve her problems. That was really not supported by the record in any way. And as I argued in my brief, the sheer brutality of this murder was so out of context for the life that Tashania Hills had been living for 24 years, no criminal history, had never assaulted a family member before, had never gotten in any trouble with the law. The brutality of the murder itself speaks for itself as to the state of mind of Miss Hills at the time it happened. And Dr. Leswing also opined on that in his testimony based on the injuries to the face area, something that he had seen when there's psychosis involved in a homicide. And I hope that the court takes into consideration all of these really disturbing facts, unfortunately, and finds for my client.
Thank you, Counselor.
Morning. May it please the court. Michael Labella for the respondent, people of the state of New York. I will primarily focus on point one as well. I would note and submit to help explain a little further too from what I had argued in my brief, that all these facts and circumstances with the record provided the jury with two possible theories to reasonably support their verdict. First being that they would be able to fully credit Dr. Bardet, the people's expert witness in this, in his conclusion that the defendant was malingering or faking the symptoms of psychosis. Then there's the other, and I would also submit there is also another theory the jury's verdict could have also weighed in, to be that maybe they partially credit both experts, where they say maybe there's something here, but it still wouldn't rise to the level of not appreciating the wrongfulness of the actions.
Look, I find it hard to believe that the malingering, that she was malingering, that it would have been malingering not just after the homicide, but well before leaving Howard University. The night of the incident, standing outside at 3 o'clock in the morning in bare feet in the snow. odd behaviors. There seems, and for what purpose? I'm going to fake a mental illness so I can murder my mother and then get off on that. Seems far-fetched, but it doesn't mean that the defense applies. It could be she was mentally ill. If mental illness were a defense, then we'd be emptying prisons right and left. It's very hard to get to the level of mental disease or defect under the criminal procedure law, penal law. And so a lot of people who are mentally ill don't get to that level. And I guess your argument is this might be one of them.
Well, Your Honor, I would more argue that in the matter of when you look at both experts, the defense experts, they had diagnosed the defendant with a major depressive disorder, but only with the psychotic symptoms. From my view of the record, none of the defense experts even diagnosed her with psychosis. They simply stated she experienced psychotic symptoms. So I would still, I would agree with Your Honor in that would not arise to a mental disease or defect. I would simply submit also too with the criticisms on top of that from Dr. Bardet's testimony, providing the criticisms regarding the defense expert's methodology for not performing the tests of the from the structured interview reported symptoms and additional malingering. They didn't even check. They didn't test for it at all. And I know too that there was the uncooperativeness between during Dr. McCord's psychological tests that was also showing a sign. So
there was an apology. I think you place a lot of emphasis on the fact that shortly after she apologized to the cousin for killing her mother, and that the people put a lot of emphasis on the apology to reflect that she knew what she had done was wrong. Why would you apologize if you didn't do anything wrong? Do I understand that argument right from your side?
Precisely, Your Honor. I focused a lot of that in my brief because I would submit it goes entirely against that element of not appreciating wrongfulness. Apologizing is exactly what Your Honor would say. It's an admission of that knowing what you did was wrong. So I had noted that on top of that with Dr. Bardet's testimony describing that there was a motive. And I understand the appellant states that this was all in the past with her and her mother, the relationship, but it still provides a background that persisted through all those years to the point where the defendant's conversation with her cousin at the scene was her still saying, "Is this about money?" Because it was clear and that they were having arguments over money for years and all the way up until the date of the murder. So and that differentiation too of saying, look, if there's this background of resentment, this background of towards the victim, this background of that establishing a murder, it helps divide as well to appreciate that this was an intentional act and not some irrational action taken. And
I think we understand your points.
Thank you, Your Honors. And unless the court has any further questions, I will rest on my papers.
Thank you. Case 687. 687 is People versus Harvey Alexander Jr.
Morning, may it please the court, Sabrina Bremer for Mr. Alexander. Briefly on point one, even if the statute applies to a hospital such as Strong Memorial Hospital, the evidence was insufficient to prove that Mr. Alexander knew that he was on school grounds when he entered the hospital that evening. Starting with the statute itself, I think that it per se does not apply to the hospital. Just looking at the plain language, the legislative history of the statute, the legislature was focused on more school settings where you have students in classrooms. While there might be learning that happens at the hospital and the medical school is nearby, I don't think that the legislative history supports a broad reading of the statute. And that's also shown in the plain language of the statute, where the legislature limited it limited it to building or grounds used for educational purposes. It's not every building that is owned by university. It's not,
Well, I think the statute came about with what happened at Cornell University in 1969 when the students invaded in a building there where there were no classes. They took that over, and that was the prompting. There was no learning going on in that particular building. But in any event, your argument is assuming Strong Hospital is a school, university, or college. Assuming that it is, I know you don't think it is. The knowledge element for this offense, he has to know that he possesses a weapon, and he has to know that it's a school, university, or college. And given this evidence that he went in, his girlfriend was giving birth, he goes into the emergency room or the hospital at Strong. Most people would not think that that's a school, right? Maybe it is, but they have to prove beyond a reasonable doubt that he knew it was. And they didn't meet that burden. Now, Mr. McCarthy would say that the knowledge element just goes to possession and then a strict liability thereafter. As long as you know you possess a weapon, if you're in a school, whether you think it's a school or not, you're guilty. That's really the dispute between you two on knowledge. Would you agree with that?
I would agree. And I think that this statute is different from the other elements dealing with weapon possession that have a general mens rea. Here, the legislature specifically added knowing to the provision, and under the penal law, that mens rea applies to every element of the offense, including Mr. Alexander's knowledge of whether or not he was on school grounds when he entered the hospital.
You would agree the case law says if you charge with knowing possession of a loaded weapon, you don't have to know that the weapon is loaded. You
Right.
agree with that, right?
Yeah.
If you're charged with possession of a weapon, you don't have to know if it's operable or not, as long as you knowingly possess. Those cases kind of cut against you. This, on the other hand, if you're charged with possessing a defaced firearm, you have to know that you're possessing the firearm, and you have to know that it's defaced. This is all the case law that we have here. So here, you think, because this is an element, not a definition, knowing applies to everything that follows in the statute.
Yeah.
Knowing possession, knowing in the school, being aware, and so forth. Matter of fact, I think the charge was to that effect here.
Yes. So I think that knowing applies to everything. And I think that there's a good reason for that, because the legislature doesn't want to criminalize, otherwise lawful conduct. If you have someone who has the license driving through, grounds that may be associated with a university, they might not know, as in the case in North Carolina, that just, by driving past these signs that they're necessarily on school grounds.
I give you credit for finding that case, by the way. Spent a lot of time on Westlaw, I suppose you did. Here, there was a sign no out front, as Mr. McCarthy says, and the people said below. When you go to Strong Hospital, it does say U of R Strong, and that would indicate possibly that you should know that it's a teaching hospital.
Possibly, whether or not the court wants to take judicial notice of some of the website material included, academic medical centers own many medical facilities, throughout the state. It doesn't necessarily mean that ownership structure means that you will be seeing a student if you go to a University of Rochester urgent care or something like that. So I don't think that someone living in Rochester seeing a U of R sign necessarily associates that sign with, oh, I'm going into a building that there are a lot of students in, that this is a teaching environment.
But you're being very generous to the legislature, which I think maybe we should be sometimes. But I don't know if they really did that for the reason you say, but Justice Lindley, mentioned the cases that deal with intent on both elements, and as you said, that's in the CJA charge in this particular case, right? But they may have just missed it too, and they never put hospitals in, and legislators may think, hey, once you're in school, too bad, but that's not what we have here.
Anything further? I mean, this doesn't really provide a great deal of relief for your client, seeing that on the higher count, he got 12 years and he's already done his time on this one, all likelihood. But you're asking us if we agree with you on this point, that it wasn't a school. You want us to send it back for resentencing on the crime for which he clearly committed. Maybe he gets it down from 12 to 11 or 10. That's what you're hoping.
Yes, Mr. Alexander is hoping for some sort of sentencing relief, whether it comes from remittal or this court reviewing his sentence in the interest of justice, particularly given the disparity between the initial plea offer and what was imposed after the trial.
Thank you.
Good morning.
Same legal issue for you, Mr. McCarthy.
Yes, it is. Marty McCarthy for the people, just for all you watching at home. In terms of the way the statute's written and what knowing is required, it's people's position that knowing only applies to the possession of the weapon. And when you refer to the CJI, I think both Justice Greenwood and Justice Lindley referred to that. You're also well aware of the preamble of the CJI that says that these charges are advisory, and it's always up to the judge to craft an appropriate charge. However, that being said, because knowing was applied to both elements, you would not, even if I'm right, I suppose, even if I'm right about the fact that knowing would only apply to the possession of a weapon, that is how you would have to evaluate the legal sufficiency argument.
Right.
And for the weight argument, you'd have to.
It's as it was charged here. Am I right that the judge charged consistent with the CGI, which said that the defendant had to be aware, number one, that he had the weapon, and number two, that he was going into a college, a school, or university?
Correct. So for legal sufficiency purposes, you'd have to evaluate it.
Did the jury also made a note with respect to that?
Yeah, and I'm trying to get to, I think we're going to be saying the same thing at the end.
Yeah.
For legal sufficiency purposes, if I'm right, you would examine it for legal sufficiency purposes, just based on knowing possession of the weapon regardless. And for your weight of the evidence review, you're bound to review it based on the charges provided to the jury. So you, in doing your weight analysis, you'd have to apply it to both.
I think, because I made this mistake before, I think that principle applies to both sufficiency and weight, but in any event, we can look at that. So your argument here is even if the people had to prove that he knew he was in a school.
Yes.
By going to the hospital when his girlfriend was giving birth, there was ample proof that he had such knowledge.
Yes, and that proof consisted of the sign he had to have passed going into the hospital, the signs he would have had to pass when he went to the maternity ward, which indicated school of medicine, school of dentistry, school of nursing. The word school were very prominent.
But for those signs, he can't be convicted. Like if it's unbeknownst to him that it's a school, like if sometimes we have classes come in here at the courthouse and we teach classes. Somebody brings a gun in here, maybe that's a different law, but it wouldn't be a violation of bringing a gun into a school here, right? Unless the defendant knew we were teaching here.
No, because the way the statute's written, it says schools or grounds used for educational purposes. That's one instance in which the statute apply. The second instance is a college, and the last instance is a university, and you're neither one of those things. So you're neither a college nor a university, nor are you a school for which. But
the hospital is a school.
The hospital is a school. It's part of the University of Rochester campus.
Gotcha.
And regardless of whether you want to take judicial notice of the website.
Right. But you would agree, and maybe legally you're correct, but you ask 1,000 people on the street, is Strong Memorial a school, a university, or a college? Almost everybody, but besides yourself, would say no.
If you stood outside of it and never went inside of it.
Yeah. And you say, is that a school, or are you going to school, or are you going to a hospital? They'd say, we're going to the hospital. What's wrong with you? But in any event, we understand
if I were to say, if you were inside and you were saying, well, this is a teaching hospital, there are all these signs, then clearly it is. And when you consider a teaching hospital, what its purpose is to teach. Its primary purpose is to teach. Its secondary and ancillary benefit is that you get healthcare as a result of that teaching.
But that's not what you're basing your argument on, the fact that the signs were there. And
Correct.
that he went past it, and there's testimony that he went past these signs, which somebody else testified that he couldn't have missed the signs.
Correct. And to go to answer your other question that you asked before, provided you are going to take judicial notice of the University of Rochester's website and the Strong Memorial Hospital's website, it clearly articulates on the website that it is. So if you were to ask somebody who hadn't consulted a website, the answer might be no.
Right.
But after consulting that website, it's undoubtedly, it has to be yes.
This is all very interesting intellectual exercise,
Yeah.
but in the real world, it doesn't mean much here.
No,
And the only case that would actually mean anything is if somebody with a permit who lawfully possesses a firearm goes into the hospital and gets charged with a felony. That's the only situation where this would come up. I have never seen that come up.
I've never seen it
And
come up.
I've researched it.
No.
So,
And I've never even seen it come up in the context of a college either, or a university. The whole driving through a campus scenario, I've never seen that either.
that being said, we got to try to get it right, even if it doesn't help the defendant appreciably, but so we will endeavor to
Well,
do
that's your
that.
job, yes. And to the final point, I don't see how the sentence on this conviction had any impact on the sentence on the greater conviction. So I don't think remittal is appropriate.
Gotcha. Thank
Thank
you.
you.
We'll go to case 689, in the matter of Natalio B. Councils are remote. Counselor Fedusky is with us, and now Mr. Greenberg, you are the appellant. Mr. Greenberg, you may proceed.
Thank you, Your Honor. I'm representing Nicole, who is the mother of the children involved, and I'd like to focus on the weight of the evidence that Nicole had neglected the eldest of the children. Because my feeling or my thought would be that if you vacate the finding of neglect of the elder of the child, then the neglect of the derivative neglect, of course, would then fall by the wayside as well. But my feeling is that when you look at the evidence as a whole, when you look at the big picture, not the specific trees within the forest, but the forest and the whole, so to speak, I don't really think that Nicole's actions really rise to the level of neglect, because the elder daughter, who was the subject of the neglect procedure, so the physicians, had her own well-documented psychiatric issues. She had gone to CPEP in the Erie County Medical Center. She had also supposed to be going to Best Self. And Mr. Graham, the caseworker on this, admitted that he was not able, this altercation that Nicole and the daughter had, he was unable to ascertain who the initial aggressor was. So, Your Honors, I would submit that this is not the case of a parent using excessive corporal punishment. Mr. Graham also conceded that the elder daughter did not cooperate with Best Self. So, I mean, that there was several suspensions from the school, that the elder daughter had problems with counseling, had problems with the schools. So, again, this is a very tragic case. But I don't think that, I mean, this is really the case of what do you do with the parent who is a child who, for whatever reasons, she can't control the child. So why should she then be charged or held liable for neglect?
Well, yeah, I'm not sure I think the way the other side looks at it is that it's not necessarily couldn't control the child, but it sounds like there were just repeated fisticuffs going on, like all out fights all the time between the mother and the eldest daughter. And
Right.
I don't know, nobody knows who started them or what, but after a while, the mother is the adult, and you would think there's another way to handle it rather than engaging in brawling with your child. And that's perhaps.
There should be better ways, of course. How old was the elder daughter when all this? I mean, you say, well, the mother's the adult. The daughter, on the other hand, was approaching the age of adulthood. So
She's 18 now, yeah. She's over the age now, yeah.
She's over the age now. So we weren't dealing with that she was doing all this to a 5-year-old or a 7-year-old.
Right. No, I agree. Yeah.
Well, regardless, is this the activity of what a reasonable parent would be doing and making this particular analysis of okay, let's bear down and we'll settle this out in the street.
I don't think a reasonable parent would settle in the street, but I mean, I don't think they were
Well,
settling in the street.
I'm not saying it, it seems as though there's a lot of physical altercations. I mean, this is how we're going to settle. A reasonable parent would settle disagreement with their child, resulting in these various fisticuffs and various actions that took place and allegedly took place in front of the younger children as well.
Well, I don't think a reasonable parent would resort to fighting or martial arts as a way to resolve family disputes, if that's what you're asking me, Your Honor. But I don't think that this is really that the case here with, with respect, because I think you had a child who may have been the initial aggressor. I mean, I don't think the record reflects that Nicole ever initiated a physical altercation with the oldest of the six children. So, I mean, I guess to answer your question, I would agree that a reasonable person would not, you know, as an abstraction, would resort to, um, like fighting as a way to resolve a family dispute. But I think that in this case can be distinguished because the older daughter, in many of these instances of fisticuffs, may have been the initial aggressor. So.
Also, what about the way the mother responded to her asthma attacks?
Can you explain further? What do you mean?
The mother didn't respond appropriately when the 17-year-old had the asthma attacks either.
She wouldn't let the child in to get her breathalyzer.
She wouldn't let her in to get her inhaler.
Well, I mean, if the court but does that incident alone arise to the level of neglect? I mean, and there may have been a backstory towards that incident, but so.
What about the fact too that obviously the daughter, you even indicated had mental health issues, and it doesn't.
Well, the daughter doesn't.
It doesn't appear. It doesn't appear as the mother, as a reasonable parent, would secure the proper mental health counseling for the daughter.
Well, I think she tried to take her to best self, Your Honor.
Was that one time? Okay, all right. I tried once, and I tried. I mean, how can you hold this against me? I took her to best self once. I mean, is that again? I keep trying to harp back on a reasonable parent. Would they do that, or would they make every initiative, every action to try and help her help in the situation? I mean, obviously.
Yeah.
Go ahead.
No, I'm sorry, Your Honor. No, see, I guess, but then how far do you go? Does the reasonable parent go? I mean, if the child is just not cooperating, then what can a reasonable parent do? And ultimately, the older daughter in this matter ended up with a placement in Hillsdale. Mr. Graham, the caseworker, admitted that Nicole was compliant with WRAP services and with best self, and so. I mean, if the reasonable parent standard, okay, you have a child has a mental health issue, and you try to get her into counseling, you try to take her to best self, you try to take her to these other programs or a CPAP at the center, a medical center, and she resists and she resists and she resists. And so at what point does a reasonable parent say, I just can't control this, and therefore and therefore maybe the placement was the best thing. And so with that in mind, was it a just decision to then hold her liable for the neglect of this child? There were many factors, that were outside of her control.
Sure. We'll take a look at that point and let's hear from opposing counsel if we could.
Thank you, Your Honors. May it please the court, Sam Fedusky for the Erie County Department of Social Services. Unless there are any questions for me, I would just rest on my brief at this time.
Hearing none, thank you. We'll go to case 695, Reader versus Reader. We have the AFC virtually on this case. Perhaps for an update. Good morning, Ms. Bates. Thank you for joining us.
Good morning, Your Honors. May it please the court. I'm the attorney for the children. The children are now 17 and 13 years old. The order appealed from is a stay-away order of protection against the appellant, Mr. Reader, in favor of my client's mother. The order did not restrain contact between my clients and the appellant. However, it probably should have. Many of the appellant's actions indirectly involve my clients, such as threats to involve them in litigation or to harm or even kill their mother, who is their only caregiver. The children have not seen their father in more than 5 years. They continue to do very well in their mother's care. Unless the court has specific questions for me about this matter or about how my clients are doing, I rest on my papers and respectfully ask the court to affirm the order of Livingston County Family Court. Thank you.
Can I ask you, at the heart of this were some Facebook posts the father was making, some derogatory Facebook posts a few years ago. Is that ceased or is that behavior continuing? Harassing nature of social media posts?
Judge, he has been, actually, interesting you should ask that, he's been contacting, as far as I know, the posts regarding mother have ceased, but he is now contacting, which is not prohibited by the order, but maybe a third-party violation, is contacting Ethan via social media, sending incredibly vile messages about the mother, and asking Ethan not to talk to the police. There is an active investigation in Avon right now. I spoke with the chief of police 2 days ago.
They're investigating harassment charges, criminal.
Correct. And possibly a violation of the order through third party, as Mr. Reader is contacting the child and in some way or the other asking Ethan to give messages to mother, which would be a violation of the order. So there is an active criminal investigation right now in Avon.
But your clients haven't seen the father in 5 years and have no desire to do so?
They have not. They do not have any desire. My younger client has not spoken to him at all. The only contact Ethan has had are these unsolicited social media messages that he's receiving, and those have started pretty recently.
Well, thank you for making yourself available this morning. We appreciate it.
I appreciate you having me. Thank you.
All right, we will move on now to case 697, Anderson versus Cintron. Mr. Greenberg's going to rejoin us virtually. At least that's the plan. Mr. Greenberg, welcome back.
Yes, thank you. Thank you for having me back. This case is very interesting case. It's from the domestic relations law, and whether the underlying the family court prompted the transfer jurisdiction to Texas, where the child is currently living with her father and her stepmother, although the father is currently on deployment to Poland because he's with the United States Army. Since the order went into effect, I think, as I would say, as they say in football, the facts have changed and the goalposts have moved, because apparently the subject child has recanted the allegations of domestic violence, and she's been living in Texas ever since. But even if you wanted to, address the basic legal argument that counsel had made, I mean, our argument is that very little of it, if any of it, has been preserved, and that even if you want to say the very narrow issue that the argument that the communications with the Texas Superior Court were not done in full compliance with Section 76A of the Domestic Relations Law, my argument is that the mother's attorney, Mr. Broderick, had all the opportunity to argue that point in family court, and that when the attorney for my client and the attorney for the child had submitted the motions to review the order retaining jurisdiction in Erie County as opposed to Texas, Mr. Broderick, instead of presenting his documentation or in his responding papers, instead of presenting documentation or other types of the proof that might persuade the court to have kept the case in Erie County as opposed to Texas, instead, and I made this point very clear in my brief, decided to a 3-page affidavit with no documents or exhibits that basically launched into ad hominem attacks against the respondent and the respondent's attorney and the trial judge. And that can be found on page 220 to 222 of the record, which I put in my brief. And I don't really think
Mr. Greenberg, can I stop you there?
Sure.
Understand you correctly to say that there has been a subsequent custody proceeding in the state of Texas?
I believe there is a subsequent in the state of Texas, yes. I mean, I don't have the precise details of it, but I do know that my client did file a petition in Texas.
Your client's father who lives there?
Right. Well, the father, I think, originally dated in Erie County, but then he went to Kansas, and then he went because he was traveling with the Army.
Right.
kept him. But I mean, I would also point out that the mother consented to the initial move away from Erie County going back several years. So this is
Okay.
not something that just happened out of the blue and she just went out down to Texas. Um, for like the case we had the other day to increase his salary by $14,000 or some
Yeah, I
amount.
mean, it would be nice to, is this the case where the AFC represented one thing and then the child admits she lied?
The
And
child,
recanted?
well, the child, I'm not going to go as far as calling the child a liar, but I will say that the child retracted her statements,
She recanted?
recanted.
We don't, yeah, we don't have the AFC here with us this morning, but last week heard from the AFC, the child initially wanted to stay with the mother up here and then now in a brief says, I love it down there. What I said wasn't true about the mother. And everything is fine down there, I guess, last we heard.
That was what she represented in the brief, yes. In her brief, and then the attorney for the child's brief.
All right, anything further?
No, I mean, I just think that it is, as I would point out in my brief, even if you were to reverse it and send it back to Erie County, what would be the procedures in Erie County at this point? Because the child's been back in Texas for over a year now. And well, what procedure would Erie County have to force her to come back to New York? So even if the appellant is correct in some abstract sense, I mean, I think that because the facts have changed and because of the recanting of the child, I'm not really sure what procedures would there be to do something about it at this point. And
I can't think of any myself.
I got one question. Mr. Greenberg, I believe that the family court on July 2nd, 2024 dismissed the mother's modification petition due to lack of jurisdiction. Is that correct?
That's correct.
I don't recall and see in the record. I don't think we have in the record a record of those proceedings at all. I don't think there was a hearing done. Is that correct? And it doesn't appear though. We don't have a record of that.
We don't have a record of that because they never went back to court on that day. Apparently Judge Carney had the conference with the Texas courts, and then she made her decision based on the conference. So I don't think anything went on the record as to what that would be.
Okay.
So,
all right. Thank you.
Thank you, Your Honor.
Thank you.
Mm.
Case number 698 is Morano versus Dusa. Duza. Thank you.
Morning.
Good
May it
morning,
please the
Counselor.
court. Joshua Lippis for the plaintiff appellant Francis Morano. I would like to briefly highlight a few of my arguments. The lower court erred when they decided that my client's longstanding use of the disputed path was merely a license and not a prescriptive easement, as was claimed. A prescriptive easement requires open, notorious, continuous, and adverse use for
What longstanding use was by your client?
My client and his family moved into that house in 1972. And starting in the mid-90s, they used this path while maintaining it to access these wetlands. Because my client purchased the property in 2015, tacking for his family and the privity that he had with them is permitted by law. Therefore, the requirements for prescriptive easement were met decades before the Duzas purchased their property and then gave him permission. My client never sought permission. They said you have permission to use it. They then revoked that permission in 2020, but since that property interest had already vested, it didn't matter.
You're saying it would be even irrelevant whether or not they revoked that particular license anyways. You already had a prescriptive easement in place.
Correct, Judge.
But did you have any evidence of that fact?
Evidence that they used the path?
Yes, that they had it. Yes, you're saying it was granted long ago, but did you have any evidence?
It was my client's own testimony, but it was also never disputed the fact that they used and maintained this path. When the Duzas moved into the property, they knew that my client was maintaining this area and storing equipment there. That is why they came to them and said, you can continue to use the path. So they were aware that my clients were using this path prior to their.
Doesn't have to be by Doesn't have to be adverse and, that they're doing it against the interests of the prior owners, and doesn't it appear that it was by consent or there's really nothing on the
Well,
record?
once we show that the use was continuous and open, the burden then shifts to the respondent.
Notorious.
It doesn't have to be notorious.
What about hostage?
Just open and continuous. But it wasn't.
Did you establish any of that? What proof are you referring to? You mentioned some deposition testimony. Where is that?
And the allegations in the complaint, which are taken in summary judgment in the light most favorable to the plaintiff.
But there's no, in opposition to the motion, the defendants moved to dismiss. In opposition to the motion, the only evidence, admissible evidence that was submitted were photographs of offense, which had nothing to do with the prescriptive easement, right? There was a memorandum of law, which you would acknowledge is not admissible evidence. There's no affidavit from your client saying I used that path all these years. There's no affidavit from your client's family or parents or anybody else. You mentioned some deposition testimony. I don't see any deposition testimony here in the record.
Well, Judge should address the fact that it was a memorandum of law and not an affidavit. That was not raised in the lower court.
Right.
The fact that this was not in that evidentiary form.
But
it was not objected to when it was included in the record.
All right, let's just take it step by step. You agree that memorandum of law is not evidence that can be considered, right? It's by a lawyer with no personal knowledge of the facts. Would you agree with that much?
I would agree that it was not in the record.
Right, so you're only saving, the only thing that you're hanging on to in reply is, well, they didn't tell me I didn't have any admissible evidence.
No.
So it's unpreserved. But they went first, they had a motion. How are they to anticipate that you're not going to submit any admissible evidence?
And they could have put a reply in, Judge, saying that the papers that were submitted by the plaintiff were in improper form, and they didn't do that. And then when I put the record in, Judge, they didn't say the memorandum of law shouldn't be included in that record. We should strike that.
So how would if we were to agree with you and write this up in a decision, how would we go about doing that? We would say that the defendant met their initial burden. You may disagree with that, but we have an affidavit from Karen, the wife, who lays forth the facts. When we bought the property in such and such date, we allowed him to use it, then we revoked it 4 years later. There's nothing in there about him using it prior to that.
Well, it was in the amended complaint, and it is based on the amended complaint as well. The judge said that they reviewed all prior papers and proceedings. So the fact that that was already submitted and was a verified complaint would mean that it is admissible evidence. And I would say based on that complaint, which is in the record, the first amended complaint says that the plaintiff in the facts section had been living there, maintaining the property for decades. And that would be the evidence, Judge, that you could rely upon to find.
Was that amended complaint verified?
Yes, it was, Judge.
Well, I have a complaint that's not verified on page 58 of the record. But in any event, I thought that the theory in the memorandum of law, anyways, was a different theory. My understanding, I'm going back a ways from when I read this, but in the memorandum of law, I know it wasn't you, somebody else at the firm, said, we have a prescriptive easement because they told us, they being the defendants, when we got there, we had express permission to use it. And you cannot extinguish an express easement without mutual consent. That was the theory in the memorandum of law, was it not?
I don't believe so, Judge. I believe that a prescriptive easement is established by that open use and open and continued use in the maintenance of the property. Now, the memorandum of law does have its issues, and as Your Honor may know, it was written by my father, who shortly after this was in the hospital. And he obviously was not at his best. As far
I
as
understand. He was an amazing lawyer, and he's got a great reputation, and so we understand where he was at this point.
Right, and it was 3 weeks later that he went to the hospital, liver disease, and he never recovered. Could he have stated it better? Possibly. I've certainly read his papers over the years, and I'm sure this bench has as well.
Right. So really, the issue on the verified complaint, that's pretty important, because without that, there's really no evidence of this tacking beforehand. I see First Amendment complaint on page 78. Is that the one you're saying is verified?
As a matter of course, we always verified our complaints.
Well, we'll take a look at that. I don't want to put you on the spot here, but it seems like that really rises or falls, whether if the defendant met their initial burden shifts to you, you need evidence in admissible form. We agree the memo of law is not admissible form. So really what your case holds on is either the complaint was verified or they didn't tell us in reply that our memorandum of law wasn't admissible.
Well, I believe that yes, I believe they should have objected to the memorandum of law
Now
that said that.
For preservation, of course, if a court addresses an issue, even if it's not raised, then it's preserved for us, and the court did kind of touch on that a little bit, but
The court,
we'll take a look at that.
the court addressed the decision as if the memorandum of law was an affidavit in my respect. As far as the prescriptive easement, there is no requirement for exclusivity, which is what the respondent said, and that with tacking, the prescriptive easement was established. And beyond that, the nuisance and trespass claims, the judge determined that there wasn't substantial interference. Now, that was more of a factual dispute that should be determined by a jury and not by the judge herself. Because if you take the memorandum or the complaint as evidence, there was allegations that it affected my client's use and enjoyment of his property.
That's the nuisance, the second cause of action for nuisance.
Nuisance and the trespass cause of it.
I don't see a trespass cause of action, but I do see the third cause of action for the West Seneca zoning court, the fence being too high.
Yeah.
I think you've abandoned that. Am I correct on that?
Well, I didn't abandon it, Judge. I just haven't addressed it because
in the brief.
In the brief, yeah.
Right. Well, it's.
I mean, it is.
Could be deemed an abandonment, but we'll look at that. But really what it is, the prescriptive easement is the most important thing to your client. He wants to keep accessing the creek and the wetland.
Yes, I would agree with that.
That's number one.
Yeah.
Then we got the nuisance, which I think you've limited to the floodlights.
Floodlights is the nuisance, yes,
Right.
Judge.
No more
and perhaps
wetlands. There were some allegations about that. That's not
the disparaging language written on the fence. Obviously, that could be taken
So
care
we're
of.
talking about lights now, only on nuisance.
I mean, your neighbor puts up floodlights facing directly into your yard. Every time you go in, your light goes up. He has dogs, and then they say this is a benefit to you, and this is after these disputes have been happening. We say that is an intentional act to try to cause nuisance.
Right. That makes sense.
The plaintiff.
And then just to be clear, for record keeping purpose, you don't want us to reinstate that third cause of action on the fence, or do you want to litigate how tall the fence is?
I mean,
I don't know if there's any damages to you on that, but
it's a couple inches, Judge.
Yeah.
My client thinks it's relevant. To me, I don't think it's a big deal. I mean,
okay.
All
right.
That's why I didn't really address it.
Right. So we understand, I think you understand, we got to look at whether that complaint's verified. We have your argument about lack of preservation. They didn't tell you that your memorandum of law wasn't.
The lack of preservation is they didn't preserve that argument for the bench. They didn't preserve it in the lower court. They didn't preserve it and object to the record when it was put forth and say, we need to strike that part of the record. Memos don't go on the record. They allowed it, and they only brought it up then. They had an opportunity to reply in the lower court, and it could have been cured in the lower court.
So we would say, if we were to reverse, we would say the defendant met their initial burden. The plaintiff in opposition submitted no admissible evidence, but they win anyways because the other side didn't say they submitted no admissible evidence. That's how we would write that up.
Well, I would say the admissible evidence was the pleadings and the other evidence that was reviewed by the court, including the memorandum of law. The memorandum of law isn't useless and therefore dismissed. It was still presenting legal arguments regarding the claims and how they should be viewed in light of the court.
Right. Well, thank you very much.
Right. Thank you, Judge.
May it please the court. John Menier on behalf of the respondents, Karen and Joe Duza. Your honors hit on a lot of points today. I'm just going to focus on those and rely on the remaining points in my brief for your honors to read and review on your own time. Essentially, there is no evidence submitted in the lower court that would rebut our burden of summary judgment. The pleadings were unsworn, both of them. There was
not verified at all.
Not verified.
None of the complaints are verified.
None of the complaints are verified, your honors, and they're all on the record. And I'm going to point the court to page 83, that is the first amended complaint request to declare a prescriptive easement and by.
Well, that's not admissible.
It's
In
not
opposition, all they have to do is submit an affidavit from the plaintiff saying, I used this ever since I was a kid, and that might get them in the game, but they don't have that.
Not necessarily, Your Honor, because the cases cited by the appellant in support of tacking, those are all prior property owners who utilized either a right of way to a lake, some of those are the cases, or utilized a path. They're prior owners.
But either way, they don't have an affidavit or testimony from anyone with any personal knowledge.
It's entirely correct. There's nothing below. There's nothing before this court in the record that would show an affidavit or an affirmation, somebody with personal knowledge of the facts of the case that they could meet or.
Right. So it comes down, counsel's correct. You didn't, in reply, point out their deficiencies in their response. Because they say it's unpreserved now.
Judge, even if we did, since we didn't, and the court below took the memo as essentially legal basis, because that's what it was. It was opposition to the legal causes of action. There wasn't any factual assertions in there that the court considered. The only factual assertions and the factual affidavits that were submitted below were my client's affidavits, and that's what the court considered as evidence. It is a fundamental error that there was no factual affidavits rebutting what we submitted below. It's simply because it wasn't raised isn't sufficient, because it's so important to impose a summary judgment motion with an affirmation or something of facts with somebody with personal knowledge of those facts. And if you don't have it, even if it's not preserved below, or I didn't submit a reply, or my clients didn't submit a reply, this court could still consider it because it's so axiomatic, it's fundamental. And you have to have that to oppose that burden.
Right.
And they don't have it below, Judge.
How about the one issue? So in your view, it really rises or falls on, did you meet your initial burden? Because if you didn't, the sufficiency of the opposition papers is irrelevant. On the nuisance claim, with respect to the lights, your client's, the wife submits an affidavit admitting that they installed lights in the backyard, in their own backyard, security lights. They admit that, and then she just, as I recall, conclusively says they wouldn't be a nuisance to a reasonable person. They don't say, your clients don't say, where were the lights installed? They don't say anything about the wattage of the lights. They don't deny that the lights shine light onto the neighbor's property. Without any of that information, can we say as a matter of law that your clients established entitlement to judgment on the nuisance claim?
Yes, Judge. We do have that information, actually. In the affidavit, it does discuss where the lights were installed. They were installed on a tree.
Where's the tree, though?
The trees, so.
And if you could direct me to the page, because I might have missed it.
One moment. Just find her affidavit in here.
I think it's on page 16. It starts 16 to 22. Then she gets to the lights on page 21. Paragraph 46. My husband installed a motion light activated security light upon the Dusa property, their property. We have multiple motion activated security lights on the property. The security lights only operate when it's dark. They're used for security and are triggered by movement. Clearly, none of these allegations amount to a nuisance to a reasonable person.
So Your Honor,
like if they were, would you agree that if they were on trees that were right next to the borderline of the properties and they shine light onto the neighbor's property, anytime there's a bird flies by or a dog or anything, that the jury might find that to be a nuisance?
I respectfully disagree, and simply because it's a motion activated light that would go on at night. And the reason why it was strategically set up in the area is because there were some issues with the plaintiff or the appellant coming through the fence area and defacing my client's fence. So that's what it was set up to deter those actions and also to deter other potential people walking through their property. I mean, it's a security light, Judge. And
So maybe it's not dismissible. Maybe it's something that jury has to determine. We'll take a look at that, but we don't know from this pleading. We have no idea all this stuff about the reason why it was set up to prevent intrusions, for all that stuff. All we know is that there's lights somewhere in the backyard that shine light onto his property when there's movement.
And only
probably look there's not a big cause of action, not a lot of money going to change hands on this thing.
Right.
I think this case is really about easement. This is a minor thing. I don't even know if they want to go forward with it, but I'm just having a hard time saying as a matter of law, this one doesn't survive.
Your Honor, I searched Westlaw for any case that would say that a security light or a motion light is a form of a nuisance.
Right.
You know,
If it's on your own property,
And
if
that's
it's on your own building, like this one is shining not on their building, they're shining on somebody else's building.
So that's not entirely accurate, Judge. It does project into my client's backyard, but where the trees are, it does, part of the light would perhaps shine on an area of the appellant's backyard, but simply because of a light shining could create a nuisance under the statute with regard to the elements.
Right.
Again, Judge, I direct the court's attention to Matt Liana. That's a Fourth Department case. The elements are very clear. Substantial interference. This is a motion light, security light that would go on at night.
Right. My only point is, and what I have to look at, and we have to look at, is whether the allegations in your client's affidavit establish what you're saying here in court. It sounds like you're adding some more facts that are undoubtedly true. I'm not questioning that, but are they alleged here? I'm going to take a look at that.
Fair enough, Your Honor. And then I would respectfully agree with the court that the last cause of action, which is for the violation of the West Seneca Town Code, that's abandoned. It was not asserted in the brief. The court granted summary judgment on that cause of action as well. If Your Honor has any further questions with regard to the adverse possession claim, because again, they were pleaded in the alternative, or there was both causes of action. It was not only adverse possession, it was prescriptive easement, which essentially is the obtaining of an easement by adverse possession. Elements are very similar. Exclusivity is the only one that's not relevant or required for a prescriptive easement. If Your Honor wants me to go through that, I'm happy to go through those.
I think you did in your brief very well.
We'll rely on the brief, Your Honor. I'd ask the court to affirm the lower court. So
Thank you.
Thank you.
Case number 700. Corbin Anderson versus Thomas Neubauer. Good morning.
Good morning, Your Honors, and may it please the court. This is a very straightforward motor vehicle accident. I won't belabor the facts of how it happened. There are two legal issues that are presented on this appeal for the court's consideration. The first is whether the facts of this car accident are extraordinary circumstances. That is the language that the Court of Appeals uses and the Fourth Department has adopted relative to whether or not the actions that were taken by my client could have possibly had anything to do with the proximate cause of the happening of
Your
this
client
accident.
was the lead vehicle
Yes, Your
on
Honor.
the 290,
Yes,
stopped abruptly for whatever reason. There's disputes as to why. Stopped abruptly in the middle of the lane.
did not stop abruptly.
Your client, the first car, didn't stop?
Stopped, not
Yeah.
abruptly. The plaintiff's own deposition testimony was that my client came to a stop in a quote, normal fashion. That is what the plaintiff testified to, who was positioned immediately behind my client. There is no evidence that my client
No other
stopped
testimony,
abruptly.
there's no other testimony from any of the other parties involved. That's right.
The other two parties were positioned behind the plaintiff and mine was in front,
There's
but
no depositions taken from them yet.
not at the time this motion was made.
Right.
That's correct.
Your client, and the reason for the stop, according to your client, was snow came off a vehicle that was in front of the client, your client's car?
My client, in her affidavit, testified that she came to a stop because the vehicle in front of hers came to a stop. And she was caused to come to a stop behind that vehicle. That's why my client stopped, because it's what the car in front of hers did.
Okay. And the plaintiff was in the second car?
The plaintiff was positioned behind my client, yes.
Yeah, and came to a complete stop, but just barely.
Came to a complete stop without striking my client's car.
And they
Yes,
got hit from behind by a third car. pushed into your client and they got hit again.
Yes.
And you're saying there's no view of this that your client did anything wrong.
Under the precedent, my client's negligence, if any, the causal link is severed. Even if my client was negligent, their causal link is severed as to the happening of the accident with the plaintiff because
He was able to stop.
the plaintiff was able to stop. And that fact is undisputed. The only way around that conclusion for the plaintiff is whether or not the facts here are extraordinary. There's two cases that speak to that, Tutrani from the Court of Appeals and Berg from this court. Both of those cases involve a sudden lane change that occurred immediately before the happening of the accident, what my office might call a swoop and stop. That is not what happened here. There is no indication that there was a lane change immediately preceding the happening of this accident. There's nothing extraordinary about what happened here.
Your client just came to a gradual slow stop in the center lane of the 290. And
Because that's what the car in front of hers did.
right, well, isn't there some discrepancy about the reason for your client coming to a stop?
I don't think it matters when my client came to a stop.
Okay, but there is some discrepancy there?
I don't believe that there is.
Was there a question as to whether your car came to a complete stop?
No, there is no question as to that. The plaintiff testified that my client came to a complete stop before the plaintiff came to a complete stop and was struck in the rear. The plaintiff testified at a deposition before this motion was made, before my client was ever a party to this lawsuit. And that is what the plaintiff's own testimony was, that my client stopped in a normal fashion. The plaintiff came to a stop behind my client without striking her. Those are the essential and undisputed facts in this case. Because of that, under the case law, we are entitled to summary judgment as a matter of law unless extraordinary circumstances are presented. And those circumstances are not presented in this case.
So your client in the affidavit says the vehicle in front of me came to a sudden stop.
Yep.
The police report talks about the reason your client came to a stop was that snow came off a vehicle in front and hit her windshield. Is that not correct?
I believe that is what was in the police report.
Right. So this is what I'm talking about. There's contradictory reports. Your client says, I came to a stop because the car in front of me came to a stop. We have a police report saying, I came to a stop because snow landed on my windshield.
It doesn't matter.
Okay, I know, but earlier I asked you, was there a discrepancy as to why it stopped? And you looked at me like I was from outer space.
My apologies.
So we have, because what your opponent's going to say is that they want to put some people under oath here. They want to do some discovery to get to the bottom of this. Is why did your client stop? You say it doesn't matter because plaintiff had an opportunity to come to a complete stop, regardless of the reason. And if you're right on that, then I suppose it doesn't matter the reason. So you don't want any discovery. Your client hasn't been deposed?
After the filing of this motion and not contained within this record, yes, my client has since this time given deposition testimony. So have the other two drivers.
Okay.
That doesn't mean that this motion should have been granted the first time, though.
Right.
It was ripe the first time, and my client should not have had to have gone through that.
Okay. You could always move again for permission to file a subsequent motion for summary judgment. Now you got all the evidence out there, right?
I shouldn't have to, but yes.
Right. You have that option.
Sure.
Okay. If, just hypothetically, you seem to suggest it doesn't matter why your client stopped.
That's correct.
Would you agree that if it was an abrupt stop, it would be different?
No, I don't agree with that.
All right. So let's say that you're following me on the 190. I negligently come to a screeching halt because I think there's a deer coming, but it's not, or for some reason, I mistakenly just come to a complete stop and I'm hit the brakes. You're traveling behind me and you're able to come to a stop right before my car. Like, whoa, what's this guy doing? But the car behind you isn't able to do that and hits you.
Correct.
You don't think you have any, do you think it was negligent for me to come to a stop for no reason at all?
I think the causal link is severed
Correct.
under
Right.
those circumstances.
But do you think there's negligence by me for stopping for no reason?
Perhaps.
Okay, so then, but because the car stopped, there's no causal link, no causal link.
That is
And
correct.
then I'm off the hook for my negligence because you were able to adroitly stop before hitting me, but the car behind you wasn't.
That's what the case law says.
Okay, I'll take a look at that. It's a little surprising to me, but you do this more than I do, and I trust you, so I'll take a look. Trust but verify, they say. I'll have to go on the Westlawn verifier.
Sure. The cases are there for your reference.
Anything else you want to add to your cogent argument?
No, if there's no other questions from the bench, I'll rest on my papers.
Okay,
Thank you, Your Honors.
thank you.
Good morning, Your Honor. Leah Costanzo for the respondent. I just want to hit on a few points. The first was the defense standard that was presented to the court that facts essential to justify opposition were exclusively in the knowledge and control of the movement. In this particular case, they are. I was never able to depose at the time that this was made. The defendant, she submitted an affidavit without any sort of cross-examination or additional questioning. Also, the non-parties, or I guess parties in this case, that had testimony relative to how this accident occurred were represented by parties. So this wasn't a position where I could submit evidence to the court that wasn't being controlled by the lawsuit.
In your motion below, though, did you say that the further discovery was needed? Was that in your papers?
Yes, Your Honor, it was.
I mean, because the court's decision was just denied without prejudice, right? The court didn't articulate that, though. The further discovery was needed. They just said denied without prejudice. Is that correct? Is that my recollection there?
Your Honor, the underlying court indicated that it was denied without prejudice so that we could complete discovery, finish discovery, and then they can renew their motion if the discovery revealed what they expected it to reveal. The indication from the trial court was that they needed more evidence based on what was in front of them, and that they believed other evidence was important to the court deciding the case on the merits.
But was that all in the record, what you just said, or was that just your understanding?
Or is it implied from the decision without prejudice?
Your Honor, I think it was both. I'd have to go back to the transcript to see exactly what was discussed, but the indication was to go back. The answer had just been filed by the defendant. It was clear that there was no discovery that had been conducted, and the court didn't have enough in front of them to make a decision. And the information that was in front of the court was unclear. Which leads into the Tetrani case, because it does matter the method of the stop, the reason for the stop, and how the accident happened. My client isn't clear on how the accident happened. He wasn't going to come to a stop on the interstate just because he wanted to. There's a reason that he came to a stop on the interstate, and it was because of the defendant's vehicle. The question becomes, did the defendant set into motion those events that caused the accident that precipitated? And in the Tetrani case, the court said it's irrelevant that the plaintiff was able to stop the vehicle without striking the officer's vehicle, because the conduct that preceded it caused this chain reaction of events that would not have occurred had that vehicle not come to a stop.
Is this an abuse of discretion standard for review here on this?
Your Honor, I think the court had discretion in this case. It should be deferred to based on the limited discovery that we have, the fact that it's premature, also the fact that there's other testimony that could implicate or will implicate the defendant and the defendant's responsibility.
You've got that testimony now.
Yes, Your Honor.
Is it consistent with this theory that you're articulating here in this case?
I believe that the defendant's testimony revealed.
It was either snow came off the car in front of the defendant and hit her windshield, and that's why she slowed down, or the car in front of her slowed down. That was what we were wrestling with here. Is there any elucidation on that?
Yes, she did testify that there was snow and ice that came off that came towards her vehicle and that she made a quick stop.
So her affidavit that she submitted in this case is not correct?
That's to my understanding, yes, Your Honor.
I guess.
Well, it's
not
inconsistent.
mutually exclusive. The car could have slowed down in front of her and the ice could have come off, I guess, right? So, but in any event.
Yes, Your Honor. In any event, it was inconsistent. There's other testimony that needed to be had. And my client was talking to other individuals who witnessed the accident at the scene. My client's testimony was that he had to swerve to try to avoid the defendant's vehicle into almost another lane. The fact that he was able to come to a stop, but then immediately was struck from behind indicates that the defendant's conduct may have precipitated those series of events.
He did testify, I just read the deposition, she's correct. Her client didn't slam the brakes and abruptly stop. It was a gradual applying of the brakes and a gradual slowing, right?
Yes, but the fact that my client was far enough behind the defendant's vehicle does not mean that the defendant was not negligent and caused the series of events, because my client may have been far enough away from her, but also had to swerve his vehicle to try to avoid her, but then was so close to her vehicle that he was hit from behind and immediately pushed into her. The series of events that happened afterwards, the accident, my client's injuries, as in Tetrani, happened right after.
Your client sued also the people that hit him from behind?
Yes, Your Honor.
Anything further?
If the court doesn't have any questions, I'll just rely on my papers. Thank you.
Good. All right, we will go to case 701, White Management Corporation versus Mountain Mart.
Good morning. May it please the court, Kathleen McCaffrey Baines for.
Ms. Baines, if we could just hold on for opposing counsel is virtual. I just want to make sure he joins us. And he is here now, so you may proceed. Thank you.
May it please the court, Kathleen McCaffrey Baines for the plaintiffs. Respectfully, Your Honors, the trial court erred in making the determination that 7 of the causes of action in plaintiff's complaint should be dismissed. The court should have accepted the facts as alleged in the complaint as true. I don't think there's any dispute that that is the standard that must be applied. But this court, unfortunately, did not do that, nor did it give the plaintiffs every benefit of favorable inferences or consider whether the facts alleged fit into any cognizable theory of recovery. Instead, the trial court determined that Plaintiff White Management Corp. Was a party to lease agreements, which facially it certainly was not. The trial court ignored the fact that White Management Corporation is a separate and distinct corporate entity from the other plaintiffs' appellants in this suit, which is undisputed. And instead, the trial court determined that 4 leases to which White Management Corp. Was not a party did control the work that is in dispute in this litigation. Without even an answer being served by the defendants, a deposition being taken, a single piece of paper discovery being exchanged, the trial court hollowed out plaintiffs' claims, eliminating numerous theories of recovery that are either alternative to or parallel to what the court permitted to remain.
Should I just ask you some factual questions so that I can be brought up to speed on the facts here? The primary cause of action here is the third cause of action, the oral agreement for the remodel, correct? The third cause of action, that's the one that's primarily in dispute?
No, Your Honor, the equitable claims, in the event, respectfully.
I didn't say the only ones.
Okay.
But at the heart of this is we have 2 leases for Dunkin' Donuts from 20 years ago. And then we have the 2 KFC leases that were subsequent to this oral agreement. That was in December 3rd of 2022. 2020. The third cause of action is based on that conversation between Mr. Monette and Brian White.
Correct, Your Honor.
And that's the basis of the third cause of action, that you promised us that you were going to do all this, that you would allow us to do all this work, remodel. We were going to convert the Domino's that is gone into KFC, all the work that's required to retrofit that half of the building. We're going to remodel the Dunkin' Donuts part. We'll take care of the work through our contractors and you reimburse us. That's the gist of the oral agreement that's alleged.
That is, Your Honor.
Now, the issue is, of course, the other side says that is barred by the merger clauses of the 4 leases. And that seems to be what the trial judge concluded as well, that the Dunkin' Donuts lease said any future modifications have to be in writing, which this wasn't. the argument on the KFC, which came 6 months later, was any prior agreements not written down, this supersedes all that. So we're dealing first with the Dunkin' Donuts leases. How do the merger clauses there don't apply here to this third cause of action?
Arguably, if they apply at all, they would apply to the tenants and the parties to the contract. White Management Corporation was neither a tenant nor a party to that lease agreement.
Okay. But Brian White was a principal in the tenant and a principal in the plaintiff here, White Management, among others, right?
Yes, Your Honor.
So, and during the complaint alleges there's a conversation between two humans, Mr. Monette and David White. You're saying David can just choose. He wasn't wearing a hat that said White Management, right? You're saying he can just choose whatever entity that he's associated with, he can just sue on that. Because some of them, you would agree, they can't be sued in the name of the tenant, M&W Foods, right?
Arguably, yeah.
M&W Foods couldn't serve because they're barred by but White Management is a different corporation with which he's affiliated. So just the change in name allows that which would not be allowed otherwise?
No, Your Honor, it is alleged in the complaint that White Management paid for the work. So regardless of which hat David White was wearing at the time of the meeting, the factual assertions, which if discovery proceeds, will prove that the work was done and performed by an entity that is not a party to one of those leases. The trial court blurred them, lumped them into one group and treated them all the same and disregarded and did not give the factual allegation that White Management Corp paid for that work the weight that it was due.
Is there any allegation that Mr. Monette knew when he was talking? I believe it was Brian he was talking to, not David, right? He was talking to the son.
At the Zoom meeting, that's correct.
No, I'm talking about on December 3rd, 2020.
Your Honor, there's a history, I think it's a 20-year history of dealings between these two entities. So should discovery proceed?
Okay, either way, it was one of the two Whites. It was David, the father, or Brian, the son.
Correct.
Who had this discussion with Mr. Monette. They knew each other a long time doing business.
Yes.
There's no allegation in the complaint that I saw that would lead Mr. Monette to believe that White Management would be doing any work or was even involved in any of this.
I don't believe, Your Honor, that allegation would be necessary to make a prima facie claim. It is alleged specifically that White Management Corp paid for the work. Now, discovery may vet out which party or which hat the plaintiff was wearing. I don't think that is either necessary at this juncture nor fatal to the claim later. Yes, sir.
But we're at the 3211 stage here. This isn't the summary judgment motion, correct?
Correct.
So let me ask you about cause of action number 6, though, the account statement. Isn't that, though, in the record? Tell me why the court didn't have enough information to go on that particular cause of it.
Your Honor, it's unclear from the record how the trial court came to that conclusion. It did not cite to a specific fact or a specific document, which was the basis of its dismissal of that claim.
Weren't those documents submitted, though?
There were documents submitted by both sides. The trial court did not specify what it relied on to conclude that the account stated cause of action should be dismissed.
Okay.
But you had to have an agreement on the account stated cause of action as to what amount was actually due. Didn't you have to have that? You had to have what amount was due on the prior agreement.
Yes, Your Honor.
Was that there?
That was, Your Honor. The bills were submitted to the respondent, and that is the amount that was stated in the account that was due on each of the different construction projects.
That was my next question on each.
Yes. So
if White, just getting back to this theory that White Management's the one that did the work, they're not precluded by the merger clause because they didn't sign the leases, then why are the White Management is not the only plaintiff here? You have M&W Foods. The two M&W Foods are plaintiffs. How are they plaintiffs here under your theory?
are you referring specifically to the oral contract
Yeah,
claim?
yeah.
Well, Your Honor, arguably, that claim could be dismissed. That could be barred by the merger clause. That could be barred by the preceding leases. But
Against those plaintiffs?
against those two plaintiffs only. That, I think that is arguably
All right.
a result
But
that could have.
you're not arguing, just so I'm clear, that it's a different subject matter. The merger clauses talk about, like, let's take with the Duncan lease. It talks about the obligations of the landlord here. Section 5 is maintenance. And the landlord shall make cause to do all repairs and replacements necessary to maintain this premises and also keep them in a sanitary, usable condition. You're not saying that the agreement 20 years later to remodel the Dunkin' Donuts side of the building is different subject matter than what was agreed to in the lease, right? You're not making that argument.
Well, Judge, at this juncture, I don't think we're wedded to a particular argument. In the pleading stage, you are allowed to plead alternatively and inconsistently. And until discovery is done, which teases out and creates a record of what work was done, what the condition of the property was before it was done, it's too early to determine whether that work was under the lease or not. And so it's for that reason why the equitable claims are there. In the event that it's ultimately determined that any or all of the work that was done.
Yeah, you can go in the alternative at this point, but so with the KFC lease, then it seems very consistent with the oral agreement, except for the drive-through language. The oral agreement talked about a drive-through for KFC. The lease doesn't mention drive-through. I believe your position is a vanilla box necessarily includes a drive-through?
Yes, Your Honor, based on the history of the dealings between these parties, if discovery goes forward, it will show that in prior builds between both sides of this caption, drive-throughs had been constructed and paid for by the landlord. In this instance, when the parties sat down, they said, hey, let's not have two sets of contractors where we're fighting. We'll do the work, you reimburse us for it. This was the first time it had been done that way, but in every prior build that involved the same parties who were at the table on this one, the landlord had constructed and paid for those
Right, so
drive-throughs.
it was mutually understood. It wasn't defined, but it was understood. So if you're right, then the oral agreement is entirely consistent with the subsequent lease with respect to KFC. KFC agreed to do everything in the lease that Mr. Monette agreed to do orally to Mr. White, right?
I'm sorry, could you repeat the question, Judge? You lost me.
No, I'm sorry. Probably wasn't a good question. Under your theory that a vanilla box includes the drive-through for KFC, everything that was promised in the oral agreement from Mr. Monette, the landlord, to Mr. White during that oral agreement, that is encompassed in the subsequent KFC lease. Because the KFC lease says, we got to give you a vanilla box, we got to do all this and that. Same obligations in your view, same requirements, same everything, right?
I don't think it has to be a binary choice, Judge. I think the oral agreement clearly made that the case. Under the lease and the prior dealings, that was the case, but should it be determined that the leases did not cover the drive-through, then plaintiffs still should have the opportunity to alternatively seek the release,
But
seek
if they're the
reimbursement.
same, then you would agree that the third cause of action for KFC should be dismissed. You can't pursue an oral agreement that's later incorporated into a written agreement.
For the tenants, yes, Your Honor, I would agree with that. Not for the White Management Corporation, since they are not a party to the lease.
So a lot turns on whatever entity David White or Brian White in his head was considering himself to be acting under during that oral agreement.
Well, yes, Your Honor, and the fact as pleaded, which must have been and should have been accepted by the trial court, White Management Corp performed and paid for the work. There's no question about that. So it's not merely who's had.
Say, we're going to do the work. By the way, we're going to have our White Management do it for us, and you got to reimburse White Management. There's no allegations that was discussed, was it?
There's no allegation of that, and Judge discovery hasn't been done on that issue. But again, I would say that specific factual allegation is unnecessary to plead the elements for a breach of contract claim. Respectfully, the trial court just jumped the gun. They eliminated avenues of recovery that are consistent or alternative theories and put all of plaintiff's eggs in the single, 4-compartment basket of the lease. If discovery ultimately reveals that the remodels and the drive-throughs were not contemplated by the lease, what the trial court has done is given the plaintiffs, whoever it's ultimately determined did the work, no course of recovery. The landlords are unjustly enriched. They keep drive-throughs. They keep the improvements.
I think what the trial judge, if I read from the supplemental record, the arguments, he seemed to suggest that White Management was in privity. White Management Corporation was in privity with the with the tenants. And you just can't, and that seemed, if the tenants were barred, then a corporation in privity with them would be barred. But one last question, I know other people have questions, this is a very complicated case, but the complaints do not allege, and maybe you could clear this up, what is the basis for the breach of contract with respect to the 2 Dunkin' Donuts leases? What does your client say that the landlord, how did he breach? What were they supposed to do that they didn't do?
Your Honor, it was the landlord's obligation to keep the building in good working repair. Those leases were almost 20 years old, and the work that the landlord had originally done when the tenant moved in was 20 years old. Updates are reasonably contemplated, reasonably anticipated to be within the scope of that lease agreement.
What provision of the lease does it say that about updates?
I don't know that it uses the word updates, Your Honor. Our argument is that updates and remodels fall within the landlord's general obligations to repair and maintain.
Under Section 5.
Correct, Your Honor.
All right.
Correct, Your Honor. Should I discuss the equitable claims? Thank you, Your Honor. So as stated earlier, if it's ultimately determined that the work is only covered, or at least at this juncture, if the equitable claims are dismissed, leaving the plaintiffs only with the status quo, which is the written leases. Ultimately, if discovery is inconsistent with our position that the work was contemplated by the leases, then there is no alternate theory of recovery.
Your argument is you can plead in the alternative and the judge didn't allow you to, he jumped the gun basically.
He did, Your Honor.
And as some of the issues that are being discussed here, those are matters for summary judgment, and that's not what we're here for.
Exactly, Your Honor. He respectfully took our legs out from underneath us, made factual determinations that boxed us into a single lane when in the broad pleading phase before an answer is even served, we should have a 4-lane highway.
And that would even go to the issue of what role the gentleman played in white management. That would be more of an issue for summary judgment than 3211.
Absolutely, Judge. And there's no factual dispute that these are 4 corporate, different corporate entities. That's not challenged. For some reason, the trial court, using his language, was not persuaded that white management was not a party to the lease.
I think what the court was, this may have influenced, I'm not saying it's correct, but the court, because you had acknowledged below that the damages, if you had the damages from cause of action 1 and 2 and 4 and 5, the 4 leases, same exact dollar amount as the 408 that you're seeking under the 3rd cause of action. So it seemed like the court was saying, you're going to get that money if you win on your breach of contract causes of action. So why do you need to go on the 3rd cause of action? That seemed to be playing a factor, probably not a legal factor, but that seemed to play a role here.
That very well may be the lower court's rationale. It's certainly not articulated in the decision that was issued. Even if that were the rationale, that presumes that ultimately it will be determined that the disputed work was governed by the lease.
Right.
If it was not, the defendant's property was improved, someone else paid for it, and that someone else should be entitled to pursue equitable recovery.
We understand.
Okay.
Thank you very much.
Thank you, Your Honor.
Counselor?
Good afternoon, Your Honors, and may it please the court. Brian Lancio for the respondents, the Mountain Mart entities. I'd like to just get right down to brass tacks on the issue related to the oral agreement and whether or not white management and their supposed claim under that agreement is affected by the merger and integration clauses in the written leases. We provided ample authority in our brief, the red brief, that the Court of Appeals has rejected the exact sort of shell game switcheroo that Judge Lindley walked through with my opposing counsel on the other side, which is that a claim that a party negotiated and obtained an agreement, an oral agreement, on behalf of a different entity or in a different capacity than that which is the party that signs the written agreement concerning the same subject matter cannot be sustained. And whether it's the pleading stage or not, that principle of law defeats the oral agreement claim. In this case, should be proceeding under the 4 leases, the 4 written agreements that define and effectively put into 2 separate buckets the parties' relative obligations to pay for certain costs, where the landlords have certain cost responsibilities. No one's disputing that. The vanilla box is one of them under the KFC leases. Maintenance of the common areas is another area under the Dunkin' Donuts leases. But the tenants have responsibilities as well. And I think I would be remiss if I didn't point out and bring to the court's attention that in the KFC lease in particular, it's the tenants or their designee who at their sole cost and expense are required to design, build, and furnish the KFC satellite store. So that makes clear, not only is there space for white management to have been the tenant's designee, which is what appears to have happened here, but there's also a clear delineation of the parties' relative responsibilities. And I'd like to address a point that Ms. Baines made with respect to white management paid for the costs here. What's actually alleged in the complaint, Your Honors, this is in record page 31, paragraphs 42 and 43, is that payment for the work performed at the properties was, quote, advanced by the plaintiff white management corp. The very next paragraph, quote, the cost for payment for the work was then booked to the plaintiffs, North Country Chicken Corp and M&W Foods, quote, in accordance with their respective leasehold interests at each of the properties. So white management didn't pay for these costs. White management advanced the costs and then charged their affiliates, the tenants. The tenants are bearing the ultimate financial responsibility, which puts these claims squarely within the four corners of the leases. If I could also address the issue with the equitable claims and the theory that if the respondents somehow prevail in showing that a particular cost item is not their obligation under the lease, that the tenants or white management, excuse me, should still be permitted to recover in equity. That's exactly what the case law forecloses. That's exactly what the Court of Appeals decision in Clark Fitzpatrick forecloses, where the parties make an agreement in writing to bear certain responsibilities and obligations. That is to be enforced, notwithstanding that had they not made that agreement, there could have been recovery in equity. So that's why even at the pleading stage on a 3211, courts regularly dismiss equitable claims that are duplicative of the exact subject matter.
Right, but what if it's determined ultimately that a vanilla box does not include a drive-through? Then it's not covered by the contract, and they want to recover for that. They say, look, we put a drive-through into your building. We can't take our drive-through with us when we leave. It benefited your building, and that's why they're pleading that in the alternative. What do you say to that?
Well, Your Honor, I would say that that's not an uncommon occurrence in commercial leases such as this, where the tenants, obtain certain rights to build out the space that they're leasing, and they may make changes that affect the structure that can't be taken with them. That's typically accounted for, and I would submit is accounted for in these leases with the rent structure and the payment obligations vis-a-vis the parties' relative relationship. And I would submit also here that the drive-through is not the sine qua non of what's going on in this case. The KFC leases actually make reference to the tenant's responsibility to obtain permission, if it's applicable, to operate a drive-through. And if it's applicable, is used with reference to the design of the store. Well, the design of the store is also the tenant's responsibility, and it's their responsibility to build it and furnish it solely at their cost and expense. So if the drive-through is not part of the vanilla box, it's part of the design of the store, which the tenants chose and which they agreed in writing was their responsibility to pay for, again, quote, at their sole cost and expense.
Yeah, but your client seemed to, in that Zoom recording that you may or may not know was being recorded, your client seemed to understand obligation to pay for all of this. And he sent an email prior saying, I'm not going to skirt our obligations. I'm not going to wiggle out of paying my share and all that stuff. The only dispute there during that Zoom call was the contractor you hired. I think it was F.H. Anderson or something like that. F.H. Alexander was charging way too much. And that was the concern is the amount of the bills, not who has to pay.
Well, Your Honor, I disagree respectfully. I think the concern is certainly the amount of the bills, but there is also a disagreement that comes through both in the Zoom transcript and I think in the emails about who has to pay for what. In fact, it's actually the Mr. White, Brian White, who sends an email referring to the fact that they calculated the amount that they wanted the respondents to pay based on a, quote, landlord-tenant split that they used the leases to determine. So, not only does that call into question the oral agreement, but again, it's very clear that there's a discussion, an ongoing discussion between the parties about who is responsible for what portions. And I would submit that it's absolutely consistent with our position for Mr. Manette in the Zoom meeting to have agreed, and in the emails to have agreed, that there is some responsibility on the part of the respondents because the leases provide for that, right? As I stated when I first stood up today, The tenants, excuse me, the landlords have obligations in the Duncan leases to make common area repairs. There's no dispute about that. And to the extent there were common area repairs performed, they paid for them. And the same
Your
thing.
client paid $750,000. But I guess that doesn't cover it all.
Your Honor, and that would be the point of dispute, whether all of that $750,000 is common area maintenance, or is it, for example, installation of a new coffee brewing machine for the Dunkin' Donuts. We just don't know. But what we do know is that the principles of law at this stage of the case do permit what the lower court ruled, which is the dismissal of the oral contract claims and dismissal of the equitable and quasi-contract claims. I don't think anyone disagrees with the statement in the record in the May email from Mr. Manette that he's disputing the invoices, right? So there goes the account stated claim. As a matter of law, 3211A1, documentary evidence that has been unchallenged all the way up to this court, gets rid of the account stated claim. There's also no dispute about the leases and what they cover. Again, the damages issue that, Your Honor, Judge Lindley highlighted how, the lower court walked through with appellant's counsel what their damages were and how they were identical in aggregate under either, if you add the 4 breach of contract claims together, or if you take the oral agreement claim in count 3, or if you take the quasi-contract and equitable claims in counts 7 through 10. It's $408,000 no matter which way you slice it. And it's because those are the costs for the work that was performed related to the leases. So everything comes back to the leases. And I just find it unusual that we're here having an argument about an oral agreement where there are 4 clearly unambiguous, no one's disputing that the leases are unambiguous, leases that define the parties' responsibilities. But
they're ambiguous. They're ambiguous as to what a vanilla box is.
But perhaps, Your Honor, I don't necessarily agree with that. I think that the leases are pretty clear on what a vanilla box is and is not. I also think that the plaintiff's allegations are very clear about what is and is not a vanilla box. They list drive-through and vanilla box separately in every single paragraph that talks about it. And, that's another point that the lower court made, is that they're not, being said to be synonymous with one another. The last point I guess I would make, unless Your Honors have other questions, is that, again, the abundance of authority that is out there and which has gone unrefuted by the appellants is that the appellant's gambit with White Management Corporation is not tenable and is not supported by the law. And I would just offer a brief policy argument for why that is, which is it would upend the commercial contracting and primacy that New York courts prize, which allow parties to negotiate knowing with certainty who they're negotiating with and what they're getting themselves into. If a party can have a separate entity waiting in the wings to sue on supposed representations that were made in the heat of negotiations but didn't make it into the final written agreement, then we can just say goodbye to those fundamental principles of New York law altogether. And the Court of Appeals rejects that. The first department, the second department, and the third department have all rejected it. I was not able to find a case from this department, but I would not be surprised if it's out there. And there's just no basis in law or, frankly, in fact, for the position that the appellants have taken with respect to the oral agreement, and of course, for the reasons I already stated, with respect to the equitable claims.
Thank you very much, Counselor.
Thank you.
Case number 702, last case on the docket is CDE Global Incorporated versus Brian Barnt. Both attorneys are remote. Ms. Valley, you may proceed.
Good afternoon. May it please the court. My name is Lauren Valley. I represent the appellants Brian Barnt, Owen Herron, Circular USA, and Circular Group Ltd. We respectfully ask the court to reverse the trial court's decision, which erroneously found personal jurisdiction over Mr. Herron and circular defendants under CPLR 302, and erroneously denied dismissal of a breach of aiding and abetting breach of fiduciary duty claim against Mr. Herron. I intend to turn first to jurisdiction. The amended complaint fails to allege any facts or purposeful conduct or actions taken by Mr. Herron or the circular defendants to sufficiently justify dragging in these non-domiciliary entities and persons who are both citizens and entities of Northern Ireland into New York, whether it be under agency theory, parent subsidiary theory, or conspiracy theory. The amended complaint is devoid of any allegations that Mr. Herron or circular defendants encouraged, solicited, responded, or even acknowledged any of the cited emails that were sent by Mr. Barnt to Mr. Herron. Unilateral acts of an in-state actor alone are not sufficient to confer or impute jurisdiction on out-of-state persons or entities, whether under any of those theories. Unless the court has a preference as to which theory to proceed with, I intend to start with agency theory.
Please do.
Jurisdiction based on agency has three main elements. The agent must be acting with the benefit of, with the knowledge and consent of the principal, and the principal must exercise some control over that agent. The allegations in the complaint fail to meet these three standards. Instead, there's only conclusory allegations that, quote, Mr. Barnt was an agent of the defendants. There's no facts that Mr. Herron acted on, that Mr. Barnt was acting on behalf of these defendants. There's no action or corresponding email that was sent, nor is there any indication that there was any agreement between these persons for the solicitation of this email.
There was never an attempt by Mr. Herron to say, "Whoa, you can't send me this information. I know that. It's, I used to work there. I couldn't do this. You're violating your fiduciary responsibilities to your employer." There was never an attempt at that. He kept receiving this documentation all along, right?
Your Honor, the receipt of information and the passive receipt of information, even if there's no corresponding action to stop or otherwise just be silent, is also not the level of control which the courts are requiring. Courts
clearly benefited the defendants, correct?
Your Honor, that's only one of the prong. You also have knowledge and consent of the principal in order to confer agency.
Are you saying Herron had no knowledge of this?
I'm saying that the mere receipt of an email does not confer or create some sort of agency.
Well, it seems as though that the documentation was being passed on and the methodology was being utilized was somewhat nefarious or violation of Mr. Barnt's responsibilities.
Well, look, you make some good points on the agency. On the other hand, it's not like he just got these emails out of the blue. They had worked together for CDE. They had negotiated or come to an agreement. He recruited them and hired them. And then he was getting all this information knowing that Mr. Barnt's going to be coming to work for him. So it wasn't just some random, I get this stuff in the mail, I don't know where it's coming from or why. It was pretty clear why it was coming from and what the purpose was it not?
The point is, Your Honor, that the case law requires, for purposes of jurisdiction, there needs to be allegations that is there, that there is an agreement. The mere communication of one person emailing somebody and having passive receipt of information doesn't create an agreement. It doesn't create that. Even the use of private emails is not evidence or indicative of any sort of illicit or misconduct or any sort of intention, let alone conspiracy to gather information. And the post hoc employment of Mr. Barnt is also not indicative or evidence of pre-resignation direction, control, overt action. And that is what's missing in the complaint. There's no corresponding act or step or intention by either Mr. Herron or on behalf of the circular defendants. This is unilateral acts or unilateral passive information, which alone, under these theories, you need more than just that.
We're only at 3211 stage, right? I mean, wherein all this could be hashed out, as far as control or knowledge, benefit, consent, as far as an agency theory that could be hashed out more so in the event for discovery. Correct?
Yes, Your Honor. Discovery is an option, and jurisdictional discovery is also a possibility. I just want to remind the court here that the plaintiff had the opportunity to amend the complaint in the face of the motion to dismiss, which outlined these deficiencies and didn't rectify or cure these deficiencies. And with that said, there was no request for jurisdictional discovery, and therefore discovery, yes, we are at the pleading stage. But again, the question is whether or not discovery is not a gateway or a fishing expedition if the complaint itself is only relying on conclusory statements and taking legal conclusions and representing them or recasting them as facts or inferences alone without any factual allegations or underlining purposeful acts for purposes of jurisdiction.
No, we understand. Why don't you move on to the next point as time is running short?
Sure. Yes, Your Honor. Just going to point next to just parent-subsidiary relationship. Trial court erred both factually and legally when it came to this jurisdiction. The court said that both Circular USA and Circular Group Ltd. were in fact parent and subsidiary. It's just factually wrong. There's no evidence, nor is there any allegation that that is true. There's actually an affidavit that says that it's actually not true. But then also, I just want to point out to the court that that the factors that are laid out in TACA Airlines, you need to show more than just, a conclusory statement that these are similar entities or there's an association. There has to be financial dependence, operational control, shared personnel, and a complete disregard. They have to be mere dependents of each other, essentially that one entity doesn't exist without the other. And I think both legally and factually, the trial court erred in that respect. And then I'll just turn quickly to conspiracy jurisdiction. For the same reasons that we kind of highlighted with the agency, again, conspiracy requires an agreement, an overt act, and intentional participation. And I just want to highlight that even though a relationship warranting inference of conspiracy is also an element, here, although they might have an association with one another, whether that be on a personal or professional level, association is not a conspiracy, nor is just passive receipt of information deemed a conspiracy in order to show overt act and intentional participation.
Thank you very much, counsel.
Thank you.
We'll turn now to opposing counsel.
Thank you, Your Honors, and may it please the court. My name is Amy Albanese, and I'm here today on behalf of Respondent CDE. I don't want to belabor this either, and so I'm just going to clarify some points here. There is a tendency on behalf of appellants here to try to downplay what is in the complaint. They want to focus on tiny snippets of the complaint and ask the court, and they ask the trial court to ignore what is actually pleaded in the factual allegations. And just as a reminder here for all of us, at the motion to dismiss stage, it's that jurisdiction may exist, and New York courts acknowledge that for personal jurisdiction, facts relevant to that determination are very frequently going to be in the sole custody of the opposing party. And so a plaintiff needs only makes a sufficient start at finding jurisdiction prior to discovery. And so I just want to go over what's actually in the complaint. Your Honors are well aware of the factual record here, but there's this tendency to act like Brian Barnt was sending emails into a void. That's not what was happening. Brian Barnt was emailing a direct competitor of CDE business information from CDE. Owen Herron, as we know, is the co-owner of this CDE or Circular Group, and he engaged in this months-long correspondence with Barnt while Barnt was working in New York on behalf of CDE. And I think what's key here is that in the midst of this, Herron registered Circular USA to do business. So this correspondence took place from December 8th, 2022 until June 27th, 2023. On April 12th, 2023, so basically in the middle of emailing with Brian, Herron registered Circular USA to do business. Furthermore, the information that Brian was sending continued to be sent after Brian resigned from CDE and had signed his employment letter with Circular USA. And
we understand those facts, and we also understand they were sent from private emails that were meant to evade and the violation of the IT rules, and that's all laid out in the complaint there. Anything you want to add of a legal nature?
Well, and so this is not a high standard to meet some control. The appellants are trying to rewrite what the standard is here. And so New York courts find that some control can be based on just the relative position of an agent and a principal and their ability to influence them. And so here we have that ability to influence him because Herron did hire Barnt, and Herron registered his company to do business in the midst of this fact gathering from Barnt, from CDE's business information. And furthermore, as far as I just want to address the affidavit very quickly. Circular alleges that, you know, the ownership structure is not what we have in the complaint. That changed after we filed the complaint. There's now a holding company that owns both Circular Group and Circular USA. That shouldn't affect the analysis that we're doing here today to establish jurisdiction. And so that's not relevant. And then finally, I would just like to quickly touch on the websites that in the reply brief, appellants bring up that passive websites cannot confer jurisdiction. At no point are we arguing that Circular's passive websites are conferring jurisdiction. We just note that these companies hold themselves out as one and the same company. And first and foremost, this was not even an argument raised prior to this appeal, and so it shouldn't be considered. But also, this is just one piece of evidence that these companies act as one, in addition to Heron clearly making the hiring decisions for Circular USA and directing Circular USA's control.
All right. Well, thank you. And I know neither one of you probably got as much time as you wanted today, but rest assured, we will have reviewed the briefs. We review them again in the record, and we will have a decision for you down the road. So thank you very much.
Thank you.